and open up a public hearing on Senate Bill 739. Cheyenne.
Madam Chair, members of the committee, Senate Bill 739 requires the Department of Corrections provide seriously mentally ill inmates with at least 5 hours of structured therapeutic activities daily and at least 2 hours of unstructured activities daily. Requires a cooling off period for seriously mentally ill inmates prior to non-emergency applications of force. Requires qualified mental health practitioners attempt to obtain inmate compliance during the cooling off period. Prohibits force likely to cause serious bodily injury with 2 exceptions. Prohibits use of chemicals except in an emergency. Prohibits isolated confinement. Directs Department of Corrections to adopt rules to implement and to provide for ongoing employee training. Describes legal actions available to inmates.
Thank you. And we have there you are, Bob Joondeph, Sarah Radcliffe, and Joel Greenberg. And I am going to ask people to be relatively brief. We took a long time on that hearing, and we've got a lot of people for the next hearing, too. Senator Shields brings meaty issues before us. All 3 bills are his today, and Senator Olson's.
Thank you, Chair Gelser, members of the committee. My name is Bob Joondeph from Disability Rights Oregon. I want to thank Senator Shields for bringing this meaty issue before you today. Disability Rights Oregon is a protection advocacy organization, and we're federally mandated to protect the rights of people with disabilities in the state of Oregon. And part of that responsibility is to receive complaints of abuse or neglect of individuals who have disabilities and reside in facilities where they receive care, treatment, and custody. Those facilities include jails and prisons. And so for many years we have worked with prisoners in various locations who have complained about conditions, and we've also worked proactively with the Department of Corrections and other and county authorities in order to respond to complaints of conditions in those facilities. We have had a memorandum of understanding with the Department of Corrections for over 10 years that allows us access to their facility to investigate complaints and respond to conditions problems. Most recently, we have received complaints that resulted in our conducting an investigation. This has to do with the behavioral health unit at the Oregon State Penitentiary. Some of you may have visited that unit. It has been a topic of conversation of the legislature in past sessions. Again, as was stated earlier, having to do with another bill, we are not here to criticize the Department of Corrections. What we are here to do is to inform you of the results of our investigation and why we feel that this bill would address some of the problems that we discovered. And so I will introduce to you Sarah Radcliffe and Joel Greenberg, who are both staff attorneys at Disability Rights Oregon, to tell you more about that investigation. Thank you.
Good afternoon, Chair Gelser, members of the committee. I'm going to talk very briefly about what the investigation that we did conduct. In the spring of 2014, we received several complaints that alleged abuse and neglect of prisoners with serious mental illness in the Behavioral Health Unit, which is a unit of specialized housing at the Oregon State Penitentiary. You would need to understand why we did this. You would need to understand what the BHU is. It was originally designed to provide very intensive mental health services, support, and treatment to the most seriously mentally ill individuals in the prison system. These were prisoners who, due to their mental illness, were not able to conform their behavior to prison rules. They were not responsive to the graduated system of punishments and privileges that are used to deter behavior, alter behavior elsewhere in the prison. And typically they would cycle again and again through periods of punishment followed by acting out, exacerbation of symptoms, severe decompensation, and another cycle of punishment. And each part of the cycle reinforced the other, and some of these men had been through those circles many, many times. So we need, first of all, to commend the Oregon Department of Corrections for understanding that this was not very productive for their staff. It exposed them to danger, and it was certainly very destructive for the prisoners who were going through these cycles, and because of that they developed the Behavioral Health Unit. In any case, the complaints we receive from prisoners, and we do get many, were very consistent and very concerning, and because of that, we determined that it was important to conduct an investigation. We did what we think is a very thorough one. We hope to publish a final report, which we will send to the committee within the next month or so. In order to complete this investigation, we interviewed prisoners. We interviewed almost 5,000 pages of medical and other records. And very importantly, we looked at videotapes of 7 cell extractions. These are instances of planned use of force where a prisoner is being forced to vacate a cell for various reasons. And the reason that those were important and that I'm mentioning them is that they allowed us to compare what we heard from admittedly very mentally ill individuals who had access to grind in many instances, in every instance, with what we could actually see. And the videotapes were very revealing, and they convince us that despite the fact that the BHU was designed to help these individuals, over time, what has happened is that the unit no longer functions the way it used to, or at least the way it should. We've also corroborated to a great extent what the prisoners and videotapes told us by speaking to 9 former and current members of the clinical mental health staff who have either worked or are still working at the BHU. What our investigation revealed in very short order is that BHU prisoners spend months and sometimes years in a 6 by 10 foot cell. There's no natural light in the unit. There's no access to the outdoors or fresh air. The prisoners have very rare opportunities to speak with another person other than through a wall to the cellmate next door. They're all in individual cells. Most are in their cells for 23 hours a day. Very few of them shower or take recreation regularly, even though DOC policies require that they be offered those opportunities daily. With that brief picture of the investigation and sort of what the unit looked like to us, I'm going to hand this over to Sarah Radcliffe, who's going to try to put it in a little more human terms for you.
My name is Sarah Radcliffe. I'm also a staff attorney at Disability Rights Oregon. So in terms of the out-of-cell programming that's theoretically available to prisoners in the BHU, Joel mentioned showers and recreation. Our investigation revealed that very few prisoners reliably access showers and recreation. Theoretically, they're supposed to receive 1 hour per week of dialectical behavior therapy, and we were surprised to learn that this isn't a group in which prisoners are interacting with each other. In fact, they're lined up in cages about the size of a telephone booth for this programming. They're supposed to receive an hour a week with a mental health counselor. And for the few prisoners in this unit who've graduated to a level C, which is the highest privilege level that's available, they receive 1 hour per week in what's called day room. In my first interview with a prisoner, when I heard about this day room, I assumed that this was a room where they might have access to playing cards or puzzles or a punching bag, some kind of activities or programming. But in fact, that prisoner that I interviewed told me that it was just an opportunity to sit in a plastic chair in front of his cell rather than within his cell, and that's what it is. Other than these meager possibilities, the men in the BHU have literally nothing to do. Personal property such as books or radios, art materials, magazines, these are very tightly regulated. We reviewed emails from BHU leadership to officers apparently responding to concerns about whether a particular prisoner should be allowed to have a single crayon. Despite the BHU's original purpose of providing robust mental health treatment, our investigation revealed that in recent years, access to crisis and routine mental health care has dwindled. Former and current mental health staff complained to us that corrections staff dominate treatment team decisions and impede their access to their clients. Sometimes they impede that access through excuses and feet dragging. This process is universally referred to as slow playing, and sometimes by simply refusing to buzz them into the building. In the absence of mental health staff influence and presence, corrections officers respond to BHU prisoners' mental health needs with riot gear, tasers, pepper spray, and a restraint chair. We reviewed numerous incidents, both the incident reports and the video footage, in which there was no crisis counseling available to prevent self-harm. Once the self-harm occurred, usually swallowing a dangerous item or cutting oneself or banging one's head against the wall, the routine approach is to pepper spray or taser the prisoner, strip him, inject him, and place him in a restraint chair, often for long periods of time, and then to impose suicide precautions, which consist of putting the inmate back into the cell naked except for a suicide smock and taking away all personal belongings. Oftentimes, even the mattress is taken away. Mental health staff reported to us that they feel pressure from officers to impose these suicide precautions for punitive reasons rather than protective reasons. Medications are administered under the threat of tasering. We reviewed a video in which a prisoner was in his bed, wrapped in a blanket, and apparently deep in sleep. Based on our interactions with this person and the reports of his neighbors, he seems to be sleeping or in a groggy state most of the time. On this occasion, he failed to respond to an order to submit to restraints to get his shot. And so officers, rather than assess whether he was being willfully non-compliant, simply tasered him in his bed to wake him up. Forcible cell extractions are also a regular occurrence. This level of violence causes lasting damage for the people on the receiving end, and it also creates a cycle of escalation and lashing out that exposes corrections officers to considerable risks. I think what really stood out to all of us that participated in the investigation was the level of self-harm in the behavioral health unit, and what we saw, what we heard from prisoners, and what we observed in the video footage and in medical records is eerily similar to what's seen across the country when prisoners with serious mental illness are kept in solitary confinement, and that is that they pace incessantly, they pound the walls, they mutter to themselves, they scream, and horrific levels of self-harm are a regular occurrence.
Thank you so much for bringing this issue to
And
us.
I'd like to turn it over to Joel Greenberg to tell a little bit further about how this bill can address some of these problems.
And I'm going to ask you to be really brief
Yeah.
because we're about 15 minutes into your presentation and we have about 15 more people to hear from today.
Good afternoon again, Chair Gilser and committee members. I'm going to skip the history and just say that there's very good understanding and consensus amongst many kinds of organizations and government entities that solitary confinement is very, very destructive for both children and people with mental illness. The nuts and bolts of our bill, the key provisions that you would need to understand and that I think are important are that it moves prisoners who have serious mental illness out of their cells on a daily basis by requiring that they are essentially out for 7 hours a day, 5 hours of therapeutic activities, which frankly could be for us, even though we're saying therapeutic, it could be the opportunity to walk around and talk to another prisoner. It could be a job. It could be simply the opportunity to socialize, a class, legal research, almost anything. And 2 hours of unstructured activities, which would be showering and recreation. They would actually get those. The other key requirement of the bill is that for planned uses of force, this is not an emergency situation, but one in which a team is collected to take a prisoner out of his cell by force, use tasers and whatnot, that those are all preceded by a cooling off period in which a mental health professional, probably a master's level person, would be consulted, go to the cell and try to cool down, de-escalate the prisoner and see if there was a more peaceful way to resolve it. It doesn't take away the ability to use force when it's necessary, but it injects a stop sign and a roadblock to make sure that it's necessary. Other than that, we're happy to answer questions. That was as quick as I could make it.
That was very good. And I'm going to have us hold the question. Senator Shields is back, and I understand he needs to leave the building. So I'm going to temporarily close the public hearing on Senate Bill 739 and open temporarily a public hearing on Senate Bill 939. Thank you all very much. Senator Shields. And the refrain is we're asked 39.
Thank you, Madam Chair.
Return to the public hearing on Senate Bill 739. And next we've got Steve Robbins, Mike Gower, and Aaron Knott. And maybe we'll let Aaron go first. I apologize for keeping you here so long.
No problem, Chair Gelser, members of the committee. My name is Aaron Knott. I'm the Legislative Director for the Attorney General in the Oregon Department of Justice. We're neutral on Senate Bill 739, but in conversations prior to the hearing, felt it might be useful to come in and talk a little bit about just one brief portion of the bill that hasn't been mentioned yet, which is at the very, very end, which empowers inmates to press private causes of action for violation of any provision within this bill. And this generated a lot of chatter within the Department of Justice because this is already a population that generates a lot of litigation. So I think we could expect that this would be a dramatic expansion of the amount of litigation that this would create. All the more so because the definition of inmate with a serious mental illness includes, it's quite a broad range, but it is including those who are experiencing presently or recently, and it includes things like substance-induced intoxication, other factors that are widespread within the population. Short form being, I think this for and estimates about what percentage of our prison population are suffering from some degree of intermittent or sustained mental illness varies, but it's consistently high, and this would provide many new avenues for civil litigation. And in the interest of time, I won't say much more except to say that there are already some avenues for litigation. Chapter 1983 provides a federal cause of action. Disability Rights Oregon has actually recently had success moving forward with some litigation around things like the use of restrained solitary confinement by using that provision. So there are some remedies in law now, mostly just here to answer questions about fiscal impact. We don't have a number yet, but we anticipate it'll be significant.
Thank you very much.
Good afternoon, Chair Gelser, members of the committee. For the record, my name is Steve Robbins. I'm the Health Services Administrator for the Oregon Department of Corrections. Very briefly, I'd like to begin this afternoon by providing you some context. Out of the 14,500 inmates that we have in custody, approximately 1,100 of them are classified as having a severe mental illness, or SMI. We're proud of the fact that 88% of that 1,100 live in our current general population. They have jobs, they're experiencing programming, and there's the 12%. They've got a proven track record of not being able to be with others, either through victimization issues, they're self-harming, or they're harming others. And dating back to a task force that occurred back in 2004, DOC has been working to improve the way that we work with this complex population. Over the past decade, we've implemented new types of mental health housing units to try and focus on crisis stabilization, work on tiered step down from crisis back into general population, and also for those that have demonstrated violence towards others. These units were all part of a process DOC was in that was on a glide path towards a purpose-built facility co-located with a state hospital in Junction City. Due to sentence reform in 2013, as well as the current inmate population forecast, Junction City is no longer a part of the 10-year plan. So the Department of Corrections is now retooling our approach so that we can meet the growing challenges within our existing resources. We believe that we are meeting our constitutional and legal mandate to provide care despite our limited resources, although we do want to continue to work with our partners in Disability Rights Oregon and able to accomplish that. I won't go through all of the concerns we have specifically based on time, but I did want to call out just a few of them. This bill would impose standards in statute beyond what we see in prisons typically and requires therapeutic treatment that is greater than even what the state hospital is working to provide right now. It's important to remember that we're not a mental health treatment facility that happens to have security. We are minimum, medium, and maximum security prisons that are trying to incorporate mental health treatment into our programming. And last, from a clinical operations perspective, This bill would require us to increase staffing to a level that we believe would be unattainable, attempting to increase our qualified mental health professionals substantively while also having to hire clinical staff on nights and on weekends, remembering that we struggle to retain and recruit staff on day shifts now. Programming space to accommodate this exponential increase in individual and group treatment requirements, it's simply not available. It would require us to discontinue other types of programming in order to incorporate these. So while these, and as was mentioned before, while these inmates have a number of existing legal recourse options, this bill adds additional legal avenues for inmates to meet these new statutory requirements. So with that, I'd like to hand it off to Mike Gower.
Chair Gelser and members of the committee, my name for the record is Michael Gower. I'm the Assistant Director for Operations for the Department of Corrections, so I oversee all the prisons. Some of the elements of this bill were spoken to earlier, so I want to talk about some of the operational impacts that would affect us. One of the ones that was brought up was the cooling off period. In the structure of the prisons, everything is time management. If we were to take a time out waiting for a behavioral health specialist to come during a cool down period, especially when they're not working or not available, that is time away that they'd have to be supervised, that would take away from other operational issues. Obviously that would impact us, and if that was to be the case, an additional staff would be warranted. The out of cell time, as they talk about 7 hours, two things that impact that. One is being out of the cells for the 7 hours would impact our operational space. A lot of these, where our restrictive housing is located, does not have the space for folks to be coming out, which means they have to be escorted to another part of the institution, which again would take security personnel, and it would probably interrupt or discontinue other operational programming. So if we had educational or A&D needs, that might be impacted in reference to trying to meet the 7 hours. It would also impact the adults in custody, that it would signal them out to the other inmate population, which would bring them possibly being targeted for extortion or assault, because now they would be different than the other inmate population. You also saw one of the elements, which would be a concern for the same reason, not being able to use chemical agents. We would not be able to identify exactly who these inmates were, and we wouldn't want to put a tag on them to make them stand out to be any different. The 7 hours or the 5 hours of structured time does not include the possibility of work as it's written. So the inmates now that have work would have to either lose their jobs. For us, that would be twofold into the negative. One, impacting our Measure 17 obligations, as well as not allowing the inmates to come up with some skill sets to reintegrate when they go back into society. We are happy to state that just recently we have been approved and will be working with the Vera Institute out of Washington for Safe Alternatives to Segregation Initiative. We're one of 5 states that was awarded this. They'll be coming out in May. They'll be looking at all our policies and procedures, and they're going to be coming out and visiting the 6, what I say is the big 6 of our institutions, to do site visits, to give us some recommendations in reference to how we can manage this segregation population.
Thank you very much.
I am trying to figure out, you say you have 1,100 severely mentally ill in the prisons.
Chair Gelser, Senator Moss-Anderson, that's correct.
So that means those 1,100 would need to have 5 hours of structured therapeutic activities every day, as well as 2 hours of unstructured activity every day.
Chair Gelser, Senator Moss-Anderson, that would be our understanding.
And what are other inmates? Do they have 7 hours, 5 hours of structured and 2 hours of unstructured?
Right now, they have almost an hour a day for 5 days, and that would include coming out for showering and shaving and exercise.
So this population all 1,100 would be treated very differently than the normal.
Chair Gelser and Senator Moss-Anderson, that'd be correct. In the restrictive housing areas, that'd be correct.
And how many of these, I think you said 12% or 125% actually have solitary confinement. Is that correct?
Chair Gelser, Senator Monis Anderson, that's correct. 88% of the 1,100 live in general population, and 12%, or approximately 125, are in restrictive housing.
This is huge fiscal. Thank you.
So colleagues, I know there are other folks that are signed up to offer testimony. Cheryl Ramirez from the Association of Community Mental Health Programs, Jan Elfers from Ecumenical Ministries of Oregon, and Kimberly McCullough from ACLU Oregon. I'm wondering if you could submit written testimony so that we can get to the next bill. I have talked to the principals, both the proponents and DOC. The bill isn't ready to move forward this session. It's a very, very important issue. The issues that are raised in the study are incredibly important, and what we've talked about is having all of you continue to meet. I understand you've started some conversations and meetings coming back before this committee to share the finalized report after Disability Rights Oregon completes its report, as well as the recommendations from the Vera Institute, looking at how we can move forward on something that's maybe a little bit more refined, manageable, to address an issue that's critically important, but also very complicated given the institutional setting that it takes place in. Is that amenable?
Chair Gelser,
yes, it is.
Great, thanks. And Bob nods from back there. And those of you that we didn't get to today, I apologize for that, but if you could send the testimony in, we'll get it into OLIS and make sure that we get to you when we talk about this again. It's April. We're at that time. So thank you all.
Thank you for your time.
Very much. And I'm going to close the public hearing on Senate Bill 739.